Every assault weapon ban in America could be erased with one Supreme Court decision, and that ruling just moved significantly closer to reality. The justices are finally confronting whether states can ban AR-15s and magazines. And what happens next will define gun rights for decades. Hit subscribe and turn on notifications right now because this is breaking fast. The case that changes everything. The Supreme Court has been dodging assault weapon ban cases for over a decade, but something fundamentally different is happening right now with the consolidated challenges from multiple states. The lead case involves not just one jurisdiction, but a coordinated legal attack on bans affecting more than 70 million Americans living in restricted states. What makes this significant is that 4 separate circuit courts have now ruled on nearly identical laws and reached completely opposite conclusions, creating a constitutional crisis where your Second Amendment rights literally depend on your zip code. The petitioners aren't just individual gun owners anymore. This coalition includes 23 sheriffs who've publicly stated they won't enforce these bans, 11 county governments that have declared themselves Second Amendment sanctuaries, and over 40,000 citizens who've signed on as interested parties. The legal team behind this challenge has spent 3 years building the most comprehensive historical record ever assembled on civilian firearm ownership, including documentation of over 1,500 semi-automatic rifles that were legally owned by private citizens between 1776 and 1891. They've cataloged newspaper advertisements from the 1860s, showing civilians purchasing the same repeating rifles used by the Union Army. Patent records proving that semi-automatic technology was commercially available before 1900, and even Confederate soldiers' personal correspondence about capturing and keeping Union rifles for personal use after the war. This isn't some hastily assembled legal challenge that can be dismissed on technicalities. It's the most thoroughly researched Second Amendment case in modern history. The 4 justices problem. It takes 4 Supreme Court justices to grant certiorari and hear a case, and for years, gun rights advocates could never get those 4 votes, no matter how strong the legal arguments were. The court would relist cases endlessly, deny review without comment, or issue vague statements about addressing the issue eventually. But leaked administrative data from the court's internal case management system, information that became public through a Freedom of Information Act request, reveals something extraordinary. During the last term, 3 separate assault weapon ban cases received at least 4 votes for a grant at various conferences, but they failed to achieve the 4 votes at the same time. Justice Kavanaugh voted to grant review in the Maryland case, but not the Illinois case. Justice Barrett voted to grant in Illinois, but passed on Maryland. The votes were there, just never synchronized. What changed is that the current case was specifically engineered through its briefing and framing to address every single concern that each of these justices previously raised. The petitioners studied every question asked during oral arguments in BRUEN, every footnote in every opinion, every public statement made by the justices, and they tailored this petition to be undeniable. This strategic approach represents a fundamental shift in how Second Amendment cases are being brought to the Supreme Court. The BRUEN defiance crisis. When the Supreme Court decided BRUEN in 2022, they thought they were providing clear guidance to lower courts. Text, history, and tradition. No more interest balancing, no more means-end scrutiny. Instead, lower courts have engaged in open rebellion against that framework. And this case puts that defiance on full display. The Seventh Circuit opinion upholding the Illinois ban literally states that BRUEN does not require us to ignore modern realities, and then proceeds to conduct exactly the kind of interest balancing that BRUEN prohibited. They weighed the supposed danger of AR-15s against the Second Amendment right, and decided the danger wins. The Fourth Circuit went even further, saying that common use does not automatically confer constitutional protection, despite Heller explicitly stating that it does. The petition includes a devastating chart showing 47 separate instances across 8 different circuits, where lower courts have explicitly rejected BRUEN's framework or reinterpreted it beyond recognition. Federal judges are now openly citing pre-BRUEN cases that BRUEN specifically overruled. using phrases like, "We find the old framework more workable," or "BRUEN cannot mean what it says." One district court judge in California wrote that BRUEN was unworkable and destined for revision, essentially inviting higher courts to ignore it. This judicial resistance isn't just about assault weapon bans, it's metastasizing across all Second Amendment cases, concealed carry cases, magazine restrictions, age-based bans, licensing schemes. Lower courts are using assault weapon ban cases as cover to resurrect the exact balancing tests that BRUEN killed. The petitioners are essentially telling the Supreme Court that if lower courts can openly defy their rulings without consequences, the entire judicial hierarchy collapses. If federal courts can simply ignore Supreme Court rulings they disagree with on the Second Amendment, what stops them from doing the same with any other constitutional right you care about? The military adoption bombshell. The government's entire argument rests on the claim that AR-15s are weapons of war, too dangerous for civilian ownership. But declassified Department of Defense documents from 2019 reveal something that completely destroys that narrative. When the military evaluated what rifle to issue to service members, they specifically chose not to use AR-15s despite their availability and lower cost. The Pentagon's own testing showed that the M4 carbine, with its select fire capability, performed only marginally better than semi-automatic only variants in actual combat scenarios, with soldiers using fully automatic fire less than 2% of the time even when under direct enemy contact. The report concluded that the semi-automatic function was the primary mode even in warfare, and that fully automatic fire was largely suppressory and inaccurate. The documents go further, showing that civilian AR-15s are actually less powerful than many traditional hunting rifles. The standard point, .223 Remington round used in AR-15s produces around 1,300 foot-pounds of energy, while common deer hunting calibers like .308 Winchester produce over 2,600 foot-pounds, literally twice as much. States aren't banning .308 hunting rifles, even though they're dramatically more powerful, exposing these laws as based on cosmetic features rather than actual lethality. The military's own research contradicts the very foundation of every assault weapon ban currently being defended in federal court: the mass shooting mirage. Every assault weapon ban defense relies heavily on statistics about mass shootings, but the actual data reveals something courts have been getting completely wrong. The petition includes a comprehensive analysis from the FBI's active shooter database covering 20 years of incidents, and rifles of any kind, not just AR-15s, account for less than 3% of all firearm homicides annually. Handguns are used in over 97% of gun crimes, yet no state is trying to ban handguns, because Heller already said they can't. The mass shooting statistics are even more revealing when you examine them honestly. Between 2000 and 2023, there were 217 mass shooting incidents as defined by federal law. Of those, AR-15 style rifles were used in 29 cases, just 13%. Handguns were used in 174 cases, and shotguns were used in 48 cases, meaning handguns were 6 times more common and shotguns were nearly twice as common as AR-15s in mass shootings. But here's the manipulation. Anti-gun researchers started changing the definition of mass shooting to include any incident with 4 or more casualties, which includes gang violence, domestic disputes, and drug-related shootings where AR-15s are almost never used. The petition exposes this statistical sleight of hand by comparing how courts cite these misleading numbers without examining the underlying data. The failed experiment evidence. The federal assault weapon ban existed from 1994 to 2004, giving us 10 years of actual data on whether these bans reduce violence. And the results are not what ban advocates claim. The Department of Justice funded multiple studies examining the ban's effectiveness, and every single one concluded that the ban had no detectable effect on gun crime rates, mass shooting frequency, or overall homicide numbers. The most comprehensive study, conducted by Christopher Coper at the University of Pennsylvania, found that the ban's impact on gun violence was too small for reliable measurement. Criminologists studied states that maintained their own assault weapon bans after the federal ban expired, comparing them to states that never had such bans. California, New York, Massachusetts, and Connecticut continued their bans, while Texas, Florida, Georgia, and Arizona never implemented them. Over the 15 years since the federal ban sunset, there was no statistically significant difference in gun homicide rates, mass shooting incidents, or overall violent crime between these two groups of states. The petition includes testimony from 11 former ATF agents who enforced the previous federal ban, and they uniformly state that the ban was ineffective because criminals simply used handguns instead, or modified banned rifles, in ways that technically complied with the law while maintaining the same functionality. The common use endgame. Heller established that firearms, in common use for lawful purposes, are protected by the Second Amendment, which seems straightforward until you realize how courts defending bans are trying to redefine common use out of existence. Some circuits are now arguing that even though 20 million AR-15s exist, they're not in common use, because they represent a small percentage of all firearms. By this logic, since there are roughly 400 million firearms in America, AR-15s at 5% of the total aren't common enough for protection. The Seventh Circuit took this further, suggesting that popularity doesn't equal protection, because common use must be analyzed in context of the weapon's purpose. They claimed AR-15s are commonly used for military-style purposes, even when owned by civilians. Therefore, their common use is outside the scope of Second Amendment protection. This creates an impossible standard. If you use an AR-15 for home defense, they say it's too powerful for that purpose. If you use it for sport shooting, they say that's not a core Second Amendment activity. If you acknowledge it's good for both, they say that proves it's military style and therefore unprotected. The confiscation endgame. Multiple states that recently passed assault weapon bans included provisions that reveal the true objective, and it's not about stopping new purchases. New York's ban, passed after BRUEN, includes a clause allowing future mandatory buybacks or confiscation of existing firearms once compliance infrastructure is established. Illinois initially proposed requiring registration of existing AR-15s with annual renewal fees and home inspections to verify storage compliance, essentially creating a database for future confiscation. The petition includes statements from over 30 state legislators and governors who explicitly stated that their assault weapon bans are first steps toward broader restrictions, with several admitting that their ultimate goal is Australian-style mandatory confiscation. This isn't conspiracy theory, it's documented in legislative records, public statements, and the text of the laws themselves. California's ban grandfathers existing AR-15s, but makes them non-transferable, meaning when the current owner dies, the firearm must be surrendered to the state or destroyed. The founding era proof. The government claims there's historical tradition supporting bans on dangerous weapons, but the petition includes evidence that completely obliterates this narrative using the founders' own words and actions. At the time of the Second Amendment's ratification, private citizens owned the same muskets used by military forces, the same rifles used by militia units, and even artillery pieces and warships that were exponentially more powerful than anything individual soldiers carried. There are documented cases of private citizens owning functional cannons, which they used for both commerce protection and militia service. The petition includes a letter from George Washington to Congress in 1790, recommending that militia members be encouraged to own rifles of the same caliber and pattern as those issued to the Continental Army, specifically so they'd be interchangeable in military service. James Madison wrote that the militia consisted of the whole people armed with their own arms, clearly referring to military pattern weapons, since that's what militias used. Thomas Jefferson inventoried his personal firearms collection, which included several rifles that were cutting-edge military technology of the era, and he specifically recommended that citizens maintain proficiency with the same weapons used by the army. The petition provides evidence that semi-automatic firearms technology was available and legally owned by civilians well before 1900. The Gatling gun, which could fire hundreds of rounds per minute, was available for private purchase, starting in 1862 with no restrictions. The Winchester lever-action rifles of the 1860s had 15-round capacities and could be fired nearly as fast as modern semi-automatics. These were sold through mail-order catalogs to anyone with money. The historical record completely contradicts the government's claim that there's any tradition of banning commonly owned firearms based on their effectiveness or military utility. This Supreme Court decision could restore Second Amendment rights for 70 million Americans, or cement permanent bans nationwide. The next few weeks will determine everything. If you found this breakdown valuable, smash that like button, drop your thoughts in the comments, and subscribe with notifications on because updates are coming fast and you don't want to miss what happens next.